is Rick Esenberg with Wisconsin Institute for Law and Liberty. So all kinds of weird stuff going on at the Supreme Court. I had Jake Curtis on from IRG, good guy, walking us through some of what now is the condition on the ground regarding the Democrats' attempts to kick Jill Stein off the ballot to clear the way for Kamala Harris not having any vote erosion whatsoever. But my question to you, Rick, is given the compressed timeline, can Will file an amicus? Can you join the case? Can anything slow this train down? Because it sounds like the liberal majority on the Supreme Court understands they're playing beat the clock.
Well, with respect to whether Will can file an amicus, that'll happen. In fact, that's happening as we speak. And, you know, we're filing on behalf of two voters. One is a Green Party supporter. The other is a libertarian. And both of them have an interest in seeing the law followed and not distorted in order to kick off from the ballot third-party presidential candidates that they would like to consider. You know, the problem with this is that if the petitioner is right, it essentially means that any third-party candidate from third party that is qualified to be on the ballot, like the Green Party, like the Libertarian Party, like the Constitution Party, they will not be able to run a presidential candidate in this state on the ballot unless they're also contesting state legislative races, or they happen to have a sitting state legislator, or they happen to have a member who holds a state office. And that doesn't affect just the Green Party. It can affect other third parties as well.
Of course it can. It affects the Libertarian Party pretty aggressively. Not every single election drafts candidates in every single race in the state of Wisconsin. So basically, you know, you're saying unless you have the wherewithal, the resources to, you know, compete with the two parties that are protected by law and statute and tradition in the United States, screw you. That's what Wisconsin Supreme Court is poised to say.
Yeah, I mean, you know, they come back and say, well, you know, there is a way to get on the ballot as an independent, but it's much more difficult. It has to be done on a state-by-state basis. It has to be done much, much, much earlier in the election cycle. And the United States Supreme Court has made pretty clear that this type of unequal access to the ballot between major parties and minor parties is problematic. It raises constitutional questions. The argument here that's advanced by the petition also raises constitutional questions with respect to qualifications for a candidate to run for office. And it essentially adds additional qualifications. If you're a member of a party who's qualified for the ballot, you have to be contesting other state races. And there's nothing in the United States Constitution that requires that. And quite frankly, it's fundamentally anti-democratic. I mean, if the Green Party wants to contest, or the Libertarian Party wants to contest state legislative offices, they certainly can do it. But to say that if they don't, they lose their ability to have their presidential candidate appear on the ballot in the same way as the Democratic or Republican candidate would appear on the ballot, raises just fundamental questions about fairness and democracy. It, I think, is a misreading of state law, and if it were a correct reading of state law, it would raise grave constitutional concerns.
All right, so let's just assume for a second that the Supreme Court is working on behalf of the DNC, because it looks like they are. So let's just assume for a second that's true. And they want to get this done so that Jill Stein's name cannot be printed on the ballots that are going to be distributed, or at least have to be ready to be printed in mid-September. There would not be time, if I'm looking at this right, for any additional challenge to be raised, like, you know, an emergency injunction, trying to seek it out, some kind of relief from the United States Supreme Court?
Oh, I wouldn't say that at all, Vicky. I mean, look, consider the redistricting case, the first redistricting case. that was filed in 21 and decided in 22. The maps had to be in place, most people believed, by sometime in April, if not earlier. A decision, as I recall, a decision from the Wisconsin Supreme Court came down in, I think, early March. The legislature and our clients, the Johnson petitioners that we represented, sought emergency relief in the United States Supreme Court, and we got it. And the decision of the Wisconsin Supreme Court was reversed, and a different set of maps was put into place. So, that may very well happen, and I don't think it's going to be precluded. I mean, you never know what the United States Supreme Court is going to do. They take very few of the cases they're asked to take. They might just ignore the whole thing or decide that it's not worth their time. But if they are interested, if they think this is an important issue, and they have been very, very protective of minor party candidates in the past, I think that there's more than enough time for somebody to seek relief in the U.S. Supreme Court.
So is the decision, must the decision from the Wisconsin Supreme Court come down by Tuesday or whatever, Wednesday, whenever the WEC is supposed to certify what candidates are going to be on the ballot? Certification may be the wrong word. I apologize. Agree to what candidates are to be on the ballot? Or is the drop dead date that mid-September date when the printing starts?
I think somebody can always enjoin the printing, but I think it's more the latter than the former. I mean, at what point is it too late to redo the ballot? I think that again, there are all sorts of procedural problems with what's happening here as well, but I don't think that this Tuesday deadline is real. But they certainly claim that it is, and the court has moved in a really astonishingly expeditious manner and has done some things that are a little bit out of the ordinary.
So I'm throwing a bit of a curveball, and I'm not sure if you've thought this through. The Democrats are, because everybody got wind of this early, are now scrambling to try to force battleground states to keep Robert F. Kennedy Jr.'s name on the ballot. While they want to kick Jill Stein off, they're developing legal strategies to try to make sure Robert F. Kennedy Jr. cannot remove his name from the ballot. Is there anything in Wisconsin that would prevent that from happening?
That's a question that I haven't looked at that, and so I wouldn't want to say what the issues there are. I would just note though that when there's this little saying that when somebody is talking about democracy, I fight for democracy, you may want to check their bona fides, because I mean, this is about, a party seeking a partisan advantage. And it is in this case, it is in trying to block RFK from being removed from the ballot, even though he's not running for president anymore. And whether they're legally right or legally wrong, it does sort of put a bit of a damper on claims that we're fighting for democracy. Democracy is what we care for. Now, I think that what political parties tend to care about is winning, and that applies to the Democrats as well, much as anybody else. And we can see the inconsistent positions that are being taken.
I have a curious question. A lot of technicalities. We're talking about a lot of technicalities here. That on the absentee ballot Dropbox case, contorted arguments to try to find technicalities to reinstall absentee ballot drop boxes in Wisconsin. And the same with the Jill Stein case, essentially reading Wisconsin law in such a way as to suggest third-party candidates are just, not welcome in our state based on a technicality. I thought the courts were loath to look at these, the minutia of technicalities when the questions about, say, disenfranchising voters were so huge?
Well, they should be. So, state law says that, the election statutes are to be construed in favor of the expression of the will of the voters. Now, that doesn't apply. That state law specifically says that doesn't apply to the process of casting absentee ballots, because that really is a privilege and it's a special way of doing things. But as a general rule, the court should be construing the statutes in a way that maximizes participation and empowers voters to express their will. And when you use, that's the technicality, although I would say not a particularly persuasive one, to knock the presidential candidate of a party that is qualified for ballot access off the ballot, you're not maximizing, you're not empowering voters. You're basically trying to take a choice away from them.
Yes.
Because I think what third-party voters are doing is they're saying to the major parties, and they know their candidate is going to win. Nobody who votes for Jill Stein or the Libertarian Party candidate thinks that candidate is going to carry Wisconsin. But what they're doing is they're saying to the major parties, none of the above. We don't like the choices that you've given us. You need to come back with better choices. And voters ought to be able to do that. And I think attempting to game the system because you assume, and I think that this assumption is it's just that. It's an assumption that Green Party voters, if they can't vote for Jill Stein, will vote for Kamala Harris. My guess is they'll write somebody else in if they have to, because they vote for Jill Stein knowing that Dr. Stein will not win, but they know in some sense that maybe that would hurt Kamala Harris in a very, very close election, but they vote for Jill Stein anyway because they're trying to send the message, and their ability to send that message is being threatened, and that's unfortunate.
I think so. The Libertarians have been a minor party in Wisconsin, but the Libertarians have been incredibly influential as a minor party on the Republican Party. The Green Party used to have some influence with the Democrats, where you didn't really get a lot of Green Party action on presidential tickets or anything like that. So, it's good to have third parties because third parties can actually have significant influence over policy, even if they don't win, Rick. And that's, I'm assuming, what at least some of the Jill Stein voters would be thinking.
Yeah, if you look at American history, third party movements have been very influential. They have rarely, if ever, won anything.
Right.
But the major political parties pay attention to what's happening, and so our system is set up in a way. Our law, our Constitution, is not set up to privilege these major political parties. It's set up to allow basically 1,000 flowers to bloom, and even if most of those flowers will not. I don't want to strangle this metaphor, but most of the time, they're not going to reach their greatest height and elect a candidate. That doesn't mean that the law doesn't permit them to try, and the law permits them to try for lots of reasons, including the fact that people ought to be able to use their vote to express displeasure with what the major candidates are doing, and that's why people vote for different candidates, and sometimes it hurts the Democrats and sometimes it hurts the Republicans.
Yeah, it sure does. Rick Esenberg, Wisconsin Institute for Law and Liberty. Thanks so much for joining me.